May I know what happened in the court today?
Please explain more.
Yeah.
Okay, yes. So, hello. Today I have filed a petition to the federal government to challenge 20 provisions in Kelantan Sharia Criminal Code Enactment 2019 as unconstitutional because the state government of Kelantan has created law beyond their powers conferred by the federal constitution. So the state governments are given power to create law by virtue of List 2 of the Federal Constitution in the 9th Schedule. However, the state government of Kelantan has created 20 provisions in the enactment which are beyond its powers conferred because the subject matter is regarding criminal offences that can only be created by Parliament. So that's all from me. Thank you.
Alright.
Thank you,
Thank you,
Nelly.
Nelly. Nelly, I have more questions.
The Federal Court has officially declared 16 provisions of the Kelantan Sharia Criminal Code Enactment 2019 as unconstitutional in a petition filed by Nik Elin binti Nik Abdul Rashid and her daughter Tengku Yasmin Natasha binti Tengku Abdul Rahman against the state government of Kelantan. In order to understand this case, let us hear from constitutional expert Ms. Sarah.
Thank you for having me, Ms. Shira. Before I explain the judgment of this case, let's talk about the facts and the background of our federal constitution. Our federal constitution is the supreme law of the land and it grants legislative power to executive parties like Parliament and the state legislative assemblies. This power is granted under the 9th schedule of the federal constitution. In List 1, which is the federal list, legislative power is given to Parliament regarding several matters, one of which is criminal law. This power is what allows Parliament to create federal-level statutes, such as the Penal Code, to punish criminals or offenders. In List 2, which is the state list, however, legislative power is given to state legislative assemblies to create laws regarding a few matters, most prevalently Islamic law. This can be seen through state Islamic law like the Kelantan Sharia Criminal Code Enactment 2019. Item 1 of the state list provides a preclusion clause which limits the state legislatures on making laws regarding Islamic criminal law, whereby the state may only create and enforce Islamic criminal law towards professing Muslims, except in regards to matters which have already been included in the federal list. Now that we understand the demarcation of powers between Parliament and State Legislative Assembly, I will briefly explain the facts of the current case. Nik Elin and her daughter challenged the validity of 20 provisions in the Kelantan Sharia Criminal Code Enactment 2019 on grounds that it is unconstitutional because the State Legislative Assembly has no legislative power over said provisions. Some examples of the provisions challenged are Section 14, which is about sodomy, Section 47 regarding incest, and Section 31 regarding sexual harassment. Thus, the issue to be decided by the federal court is whether the State Legislative Assembly of Kelantan has created provisions beyond their legislative power granted by the federal constitution. It is important to note that the enactment is a man-made law, which is also known as takzir, and if it is challenged, it cannot be said that the challenge is against Allah. Hence, it is made very clear in the judgment by the federal court that the issue is not one that threatens the position of Islam, rather it is an issue regarding the state government's authority to create laws. On 9th of February 2024, the federal court held in an 8-1 majority decision that 16 out of the 18 provisions challenged were null and void on the grounds that the Kelantan State Legislative Assembly created laws which they did not have legislative power over. During the proceeding, the petitioners withdrew 2 provisions which they originally challenged, that is Section 5 and Section 37 subsection 1 paragraph A. Hence why there are only 18 provisions that were challenged in the official proceeding. The court used the pith and substance test to determine the validity of each provision. The principle of this test is that if the State Legislative Assembly has created a provision regarding a matter in the federal list, the State Legislative Assembly does not have power to create said provision as per the case of Muhammad bin Daud and others and Government of Malaysia. Out of the 18 provisions challenged, 2 provisions, Section 13 and Section 30, remained valid because the provisions aimed to control the beliefs of Muslims and to restrict any development of doctrines amongst Muslims, which does not necessarily disturb the peace of the people as argued by the petitioners. However, the remaining 16 provisions were held to be null and void because the respondents have created laws regarding matters which it does not have power over. Thus, we can identify here that state legislative assemblies in Malaysia must ensure that when creating state-level laws, it mustn't overlap with federal law. What we can conclude is that there is still a limitation to Islamic criminal law in our country, which can be seen through the preclusion clause in Item 1 of List 2 provided by the Federal Constitution. Back to you, Ms. Shira.
Oh yeah, yeah, sure.
Actually, I have a question for you about the previous lecturer. I think I have a big confusion about the Sharia criminal law, which include hudud, takzir, and qiyas.
Oh, that one.
I think I want to ask you to elaborate more on it.
Yeah, actually, I just read it just now. So I would love to explain it more to you. Let's see. Actually, Bismillahirrahmanirrahim. Now, let us look into Sharia criminal law together with me. The object of the criminal law is to control the commission of the crime so as to protect the rights and interests of the public and ensure peace in the society. The Islamic criminal law has prescribed various crimes and has provided deterrent, reformative, retaliative, and other kinds of punishment for them in order to maintain peace in the society and reform the offenders. The Quran states in Surah An-Nisa, chapter 4, verse 1 to 3, "Not your desires nor those of the people of the book can prevail. Whoever works evil will be requited accordingly, nor will he find besides Allah any protector or helper." The jurists therefore unanimously agree that the enforcement of the Islamic criminal law is the foremost duty of an Islamic state so as to protect the society from the evil effects of the crime and reform the offenders and evildoers. The Islamic criminal law, being universal law, revolve about the following 5 fundamental objectives, which is the first one is protection of religion, protection of life, protection of lineage and dignity, protection of akhlaq, and protection of property. The 4 basic sources of Islamic criminal law has been used in order to derive the Islamic criminal law, which is the Quran, the Sunnah, the Ijma, and Qiyas. The word jurm, jarimah, and jinayah are used for crime and offense in Islamic criminal law. Jurm literally means to cut off. In Surah Al-Ma'idah chapter 5 verse 8, it stated that, "O you who have believed, be persistently standing firm for Allah, witnesses in justice, and do not let the hatred of a people prevent you from being just." In conclusion, the word jurm means a sin, a crime, a fault, an offense, or a disobedience, a transgression, whether intentional or committed through inadvertence. Now, we will further discuss regarding the punishment classification for crimes. First, qisas means equality in the offences and the punishments. In accordance with the principle of justice, the punishment for the offender is the same with the offence that he has committed. Such as, killing is punished with death penalty. Injuring a person is retaliated with the offender to be similarly injured. Nevertheless, if the families of the victim forgive the offender, then the offender is required to pay diya. Right of an individual, it can be remitted by the victim or his heirs. In addition, the offense of killing others or injuring others will require a complaint to be made against the offender for him to be prosecuted. Next is hudud. Hudud literally means boundary, limit, barrier, or obstacle. Punishment fixed by Allah in the Quran and Sunnah, a right of Allah. Hudud cannot be increased, decreased, altered, or remitted by anyone, even the head of an Islamic state. Unlike qisas, for hudud offences, there is no requirement for any claim or any complaint made against the offender before any prosecution can be initiated. Hudud punishment are awarded in 7 cases. The first one, punishment for theft, is amputation of hand. Punishment for fornication or adultery is stoning for a married person or 100 lashes for an unmarried person. The third one is false accusation of adultery. It will be punished by flogged with 80 stripes. The next one is apostasy, which will be punished with death penalty. Then, wine drinking will be punished for inebriation by 80 lashes. The sixth one is highway robbery, will be punished by death, cutting off a leg and an arm for opposite direction or an assault according to the seriousness of the crime. In the rest of cases, ta'zir will be applied. Next is ta'zir. Ta'zir means to prevent, to honor, to correct, to moderate, to avoid, or to assist. It signifies punishment for a crime for which punishment has not been fixed by the Quran and the Sunnah of the Prophet Muhammad sallallahu alaihi wasallam and has been left to the discretion of the ruler or the judge to fix it in accordance with the prevailing circumstances so as to reform the culprit and restrain him from committing the crime and to restrain others from committing the crime. Taksir offences may relate to offences against Allah or offences against mankind. These offences also not related to punishment for hudud offences or kafara. Kafara is a form of penalties for certain offences. Kafara is similar to hudud offences in that the punishment is already fixed in Islam. Hudud punishment will not be applied in cases of doubt. As stated in a hadith of Prophet, prevent the application of hudud punishment as much as you can whenever any doubt persists. That's all from me. Assalamualaikum.
That's it. Did I clear your confusion, Shira?
Yes, definitely, Ustazah. Thank you for enlightening me to the matter of
Subhanallah.
Sharia criminal law. Now I understand better.
Yeah. You're so good.
Alright.
Dek, skrabu dia, Dek. Skrabu. Hai. Assalamualaikum. Skrabu. Dek. Nak beli nasi skrabu?
Tengok sikit dapur tu.
Ada kuih, ada skrabu, ada nasi daging, ada nak mana?
Oh, nasi daging sos, nasi kerabu sos.
Boleh. Kejap, Dek.
Okay.
Terima kasih Madi beli ni awak order, Dek. Nasi skrabu, nasi daging.
Terima kasih, Mek.
Terima kasih. Awal nak jual ni, ah.
Tahu kau pasal kes ni Elin baru-baru ni.
Kes apa?
Kes yang kat mahkamah tu, viral tu.
Oh, kes ni Elin. Tahu.
Cuba Mek explain sikit pasal syariah kriminal kod Kelantan.
Syariah kriminal kod Inat berkata tu.
tu lah.
Okay, boleh.
Okay.
Max explain, Dek.
Hey, what's up guys? This is Mek Yang. Unknown to all, she is actually a Sharia lawyer. She only sells nasi kerabu during her free time as one of her hobbies.
Alright, so the Kelantan Syariah Criminal Code Enactment 2019 was passed by the Kelantan State Legislative Assembly in 2019 and came into force on the 1st of November 2021. It replaced the old 1985 enactment. In 1993, Kelantan introduced the Sharia Criminal Code 2 enactment, mostly known as the Hudud enactment. Despite receiving the royal assent in 2015, the enactment does not have legal effect as the punishments in the enactment are beyond the maximum permitted under the Sharia Court Criminal Jurisdiction Act 1965 Act 355, which only allows a maximum of 5,000 ringgit in fines, 3 years of imprisonment and 6 strokes of cane. However, it must be noted that these provisions limits the jurisdiction of the Sharia courts within the confines of the 9th schedule of the Federal Constitution. So the 2019 enactment expanded acts that are considered criminal under the Sharia law. 33 new sections have been added from the 1985 enactment of 35 sections, with a total of 68 sections making up the new 2019 enactment. So there are 9 parts under the enactment, which are first, preliminary; second, ta'zir offences relating to the protection of religion; third, ta'zir offences relating to the protection of person and dignity; part 4, ta'zir offences relating to the protection of mind and consumption; part 5, ta'zir offences relating to the protection of property; 6, ta'zir offences relating to the protection of offspring; 7, abetments and attempts; 8, general exceptions; and lastly, part 9, general. The 2019 enactment also modified and amended the existing sections by making the punishment more severe, whilst expanding the power of the Sharia court by empowering the courts to replace or add other alternative punishments such as community service and rehabilitation. So arguably, the alternative punishments under the 2019 enactments go beyond the maximum punishment permitted under the Act 355. This is a clear usurpation of Sharia court to the civil court's jurisdiction as enshrined in Article 121 of the Federal Constitution. With the 2019 enactment coming into force, the Kelantan Islamic Department and courts are empowered to implement the enactment by taking actions on the wide-ranging areas that the enactment penalizes. The enactment reinforced a narrow brand of Islam on its citizens. While the enactment is only applied to Muslim persons, it has an extensive impact on all persons in the state of Kelantan. let me provide you with 3 of the provisions out of 18 provisions in the Kelantan enactment that have been challenged by Nick Allen in her case. First is Section 14, Liwat. Second, Section 16, Intercourse with corpse. Section 17, Sexual intercourse with non-human. 3 of that matters have already been provided by the Penal Code in the Section 377.
Gitulah cerita dia.
Oh gitu cerita dia. Oh mesti akak penat ni. Terang pada.
Kasihlah dia.
Okey lah kak. Besok dah.
datang lagi deh.
Besok saya beli lagi stok
Okay,
lah.
bye.
Assalamualaikum.
Comparison of provision between Kelantan Syariah Criminal Code 1, Enactment 2019 and Sharia Criminal Law. The first Sharia offences is drinking alcohol or intoxicating drink. Definition of the offence is consumption of intoxicating substance. The authority for the prohibition of drinking intoxicating drink come from the Quran. O ye who believe, approach not prayer with a mind of default until ye can understand all that ye can see. Based on Surah An-Nisa, verse 43. Requirement to prove the offence under Islamic Sharia law, the offence of consuming intoxicating drink can be proven through either a confession by the accused or the testimony of 2 male witnesses. Under Kelantan Syariah Criminal Code 1 Enactment 2019, the evidentiary requirement under the Kelantan Syariah Criminal Code are similar to those under traditional Islamic law. However, the actual enforcement may be influenced by procedural constraints imposed by the federal legal framework. Under Islamic Sharia law, the punishment for drinking intoxicating drink varies according to different school of Islamic thought. According to the school of thought of Imam Ash-Shafi'i, the punishment is 40 lashes, and according to school of thought of Imam Malik, Imam Abu Hanifa, and Imam Abu Hanafi, the punishment is 80 lashes. Kelantan Sharia Code 1 under Section 35, subsection 1, the punishment for consuming intoxicating drink includes a fine not exceeding 5,000 ringgit, imprisonment for a term not exceeding 3 years, and flogging not exceeding 6 strokes. This provision illustrates the commitment to maintaining traditional Islamic jurisprudence while also adapting to the contemporary legal framework and ensuring compliance with federal law. The next Sharia offence is adultery, zina. The definition of zina refers to willful sexual intercourse between a man and a woman who are not and do not expect to be validly married to each other. The prohibition against adultery is stated in the Quran. Nor come near to adultery, for it is a shameful deed and an evil opening the road to other evil. Surah Al-Isra, verse 32. Requirement to prove the offence under Islamic Sharia law. Proving the offence of zina require either a confession from the accused or the testimony of 4 male witnesses. Under Kelantan Syariah Criminal Code 1 Enactment 2019, it adopts the traditional requirement of confession or testimony by 4 male witnesses. However, the enforcement is limited by the federal law. Under Islamic Sharia law, the punishment for adultery is derived from Surah An-Nur, verse 2, and varies based on the marital status of the offender. For an unmarried person, 100 lashes, and for a married person, death by stoning in a public setting. Under Kelantan Syariah Criminal Code 1, Enactment 2019, Section 46, subsection 1, a fine not exceeding 5,000 ringgit, imprisonment for a term not exceeding 3 years, flogging not exceeding 6 strokes. This provision underscores a strict evidentiary standard and severe penalties associated with an offence of adultery in both traditional Islamic law and its contemporary legal adaptation, while also highlighting the constraint imposed by the federal legal framework.
The next Sharia offences is qazaf. Qazaf or false accusation of adultery can be defined as accusing a sane and adult Muslim who has never committed zina or denying the legitimacy of a child. In the Holy Quran, in Surah An-Nur verse 4 states that, and those who launch a charge against chaste women and produce not 4 witnesses to support their allegation, flog them with 80 stripes and reject their evidence ever after. For such men are weak transgressor. This verse not only prescribes a strict punishment of 80 lashes, but also permanently discredits the testimony of those who falsely accuse others of adultery, branding them as weak transgressor. In line with this divine injunction, our Sharia criminal law enforces similar penalties. The traditional requirements include either a confession or the testimony of 4 male witnesses. However, practical enforcement is sometimes constrained by federal law, making actual implementation complex. Specifically, the Kelantan Sharia Criminal Code Enactment 2019 under Section 51 stipulates a fine not exceeding RM5,000 up to 3 years of imprisonment and 6 lashes. This code maintains the same strict burden of proof, ensuring the false accusations are not taken lightly and that justice is upheld. The last Sharia offences is apostasy. Apostasy is the act of renouncing Islam. Is another critical issue addressed within our legal framework. In Surah Al-Ma'idah verse 86, but those who reject faith and belie our signs, they shall be companions of hellfire. The severity of this act is further reinforced by the hadith narrated by Ibn Abbas, where the Prophet Muhammad, peace be upon him, said, "Whoever changes his religion from Islam to anything else, bring an end to his life." Under traditional interpretation of Sharia criminal law, the punishment for apostasy is the death penalty. However, the enforcement of this punishment is subject to certain requirements according to Muslim jurists. Our Sharia criminal code requires clear, voluntary renunciation witness or confess before such a severe punishment can be considered. In Kelantan, the Criminal Code Enactment 2019 under Section 6 provides a more measured approach. It stipulates a fine not exceeding RM5,000 up to 3 years of imprisonment and 6 lashes for the offence of attempting to renounce Islam. This enactment emphasized the necessity of clear proof or confession along with provisions for potential rehabilitation, ensuring compliance with constitutional protections and the fair treatment of individuals. To sum it all up, these are comparisons of provisions between the Kelantan Sharia Criminal Code Enactment 2019 and the original Sharia criminal law. Even though there are some differences between the state of Kelantan and the original Sharia criminal law in the terms of types of punishment and requirements, it is best to believe that every law seeks to balance justice and compassion. It is our duty to uphold these principles and ensure that they are applied fairly and judiciously.